So, good morning everyone. I would like to thank Major General Nirendra Kumar ji for taking wonderful initiative to provide a syllabus for various subjects of the domestic law as well as international law. And I have been asked to share my ideas about a very specific aspect on the international criminal law, how to structure a course, what are the contents should be there, and what are the important books and readings are there that I am going to discuss in due course. Let me briefly introduce myself. I am Professor Manoj Kumar Sinha and currently working as Director of Indian Law Institute. I am also associated with the Indian Society of International Law, and I have a deep interest in the subject related with the international law in general, both branches, public international law and specific branches of international law. The topic which I am going to focus on the international criminal law. Why all of a sudden international criminal law become an important subject which needs to be understood for a student. I'm pained to say that some way that Indian universities, colleges are still not opened up to accept this subject as a regular, either in the form of the elective courses or in a form of a compulsory paper. I hope days to come that Bar Council of India and other regulatory bodies, University Grants Commission, they include a subject as a international criminal law as a one of the important subject should be taught in the law colleges in third year, fourth year or fifth year, wherever it depends upon the university and colleges. Why I am saying so? That is the first question, why I am saying so? And this today is an occasion, I feel there is a strong justification to assert once again the importance of international criminal law, once again the importance of international humanitarian law, once again importance of the international human rights law and refugee law, of course along with the public international law. Any attempt to start any branches of international law without looking into the public international law will not be adequate. So, what a teacher has to start is a public international law. Public international law in general, a lot of topics are there, but 2-3 important areas which needs to be focused by honorable teachers or respected teachers in the university, that branches public international law, the sources of international law, relationship between international law and municipal law, and also under the United Nations Charter. If these are the topics we discuss and then we go to the international criminal law, that will become very important. Now come back to the one important point which I started actually on the why we should study international criminal law. Is there any need? Is there any relevance to read the international criminal law, or is there any relationship between the domestic criminal law or international criminal law? What is the, and then the second important aspect, what is the jurisdiction of international criminal law? Is it possible to think about a criminal law having impact on a sovereign state from outside? These are the questions which like disturbs all of us, which force us to think the relevance, importance, and we start questioning about the importance of the international criminal law. Let me begin. I will not go back to the history. The importance of the international criminal law is like it got its due recognition. If I say it got its due recognition up on the 17th July 1998. 17th July 1998. The 17th July 1998 is a day when Rome Statute was adopted. Rome Statute, the first time it was after the adoption of Rome Statute, it has created a permanent international criminal court located in The Hague. Prior to 1998, we had occasions where we have seen application of international criminal law, application of international humanitarian law in a various phases. But those steps were more in an ad hoc manner. They were not in permanent, they were more in an ad hoc manner. They were not in a permanent in nature when we talked about the earlier. And we can go back to the two famous trials after the end of the Second World War. The famous trials are Nuremberg trial and Tokyo trial. So, what we see after the end of the Second World War, the international community, the allied power, they decided to prosecute those who are responsible for committed heinous crimes. From the before the Nuremberg trial, it's a Nazis officials or Nazis authorities were responsible, and in the Tokyo trial, Japanese officers were responsible for they were the subject of the trial. So, we see that attempt of the development of international criminal law started in a more concrete manner. I do not want to go in the historical past, we can go to the historical also, but we can start from there. That we witnessed that the attempt to recognize the importance of international criminal law started with in a year 1945 after the end of the Second World War by creation of the Nuremberg trial and later on Tokyo trial. After the completion of these two trials, almost international community has remained silent, though there were efforts initially after the end of the after the trials of the both tribunals, that we should have an permanent international criminal court. The importance has been felt, but somehow it did not work out, and the idea to have a permanent international criminal court or recognition of international criminal law is it has been almost ignored, or it has not got its due recognition. After much a gap, we saw again the efforts to recognizing of the international criminal law started by the two important crises, that is the first the former Yugoslavia and second in 1990, second in the Rwanda crisis. So, one in 1993 and another in 1992. So, what happened in 1993 after the end of the conflict which would take place in the Yugoslavia and also in the Rwanda, the international community again felt that there is a need to try those who are responsible for gross violation of international humanitarian law. They must be prosecuted. So, what they spoke about? They highlighted about we must try those who are responsible for grave breaches of the Geneva Convention, grave breaches of the international humanitarian law. And Security Council of the United Nations created two subsidiary bodies, International Criminal Tribunal for Yugoslavia and International Criminal Tribunal for Rwanda. The second stage after 1945, again it was more in an ad hoc manner. It only specified, it only focused on the particular region. It had mandate to try only the persons who committed crime in the former Yugoslavia. And the other hand, Rwanda tribunal had a mandate to try those who have committed crimes in the Rwanda. So, that is the only limited, it is not universal. But in both trials, universal principles were applied. So, we see that journey starting from the Nuremberg trial, Tokyo trial, and then subsequently Yugoslavia, former Yugoslavia, by creation of the International Criminal Tribunal for Yugoslavia, and later on in just within 1 year in 1994, creation of International Criminal Tribunal for Rwanda by the Security Council of the United Nations. After that, once it ended, the international community was deeply engaged in the drafting of the Rome Statute. They thought a time has come to establish an international criminal court, a permanent international criminal court. What we have learned so far, the first, second, third, fourth, what I mean, the first Nuremberg trial, Tokyo trial, Yugoslavian trial and Rwanda trial, and others are equally going on. There are other trials are there, but I will focus here. There are other important international trial is taking place, where the principles of international humanitarian law, principles of the international criminal law are being applied. So, these are the like ad hoc. So, but the most important development, though it took long time, is about the creation of a permanent international criminal court. And as I started, I said the importance of day, and that permanency has been brought on 17 July 1998. And then we see, and skeptical people were very doubtful whether the internal Rome Statute will come into effect. When we talk about the adoption of the Rome Statute, as a law teacher, you have to also, a law teacher, political science teacher, or any other subject teachers, that Rome Statute, though it was adopted on the 17th July 1998, but it did not enter on that day, it did not become real. A statute was adopted because it required certain ratification need to be fulfilled. So, treaty says, Rome Statute says that Rome Statute will become effective. Rome Statute will become effective only after getting 60 ratification. I am very happy to say that 60 ratification Rome Statute has got in a very short span of time. Within 4 years, Rome Statute has got required number of ratification in the 2002 and 2003 onwards. Rome International Criminal Court started functioning. International Criminal Court started functioning, and now it has number of cases are there. I am not going on the jurisdiction other aspect, but I said the importance. The second important point, so journey I have elaborated. The second important point, as a teacher we have to also ponder over. So, the first basic question, whether it is LL.B students or LL.M students, they try to understand what international, how you will define international criminal law, definition of international criminal. So, a acceptable definition may be said that international criminal law consists of the branches of international human rights law, international humanitarian law, and international refugee law. If you put that international, so international criminal law actually it works together with largely with the international human rights law and international humanitarian law. In fact, it has provided a new lease of life to the entire Geneva Convention, international humanitarian law. International humanitarian law, when we talk about, and which is very essential component which needs to be taught under the international criminal law as well, which is very need to be taught. So, when we talk about the international humanitarian law, we see that there is a problem in implementation enforcement. So, now certain principles like war crimes, crimes against humanity, grave breaches of Geneva Convention, they become part of the Rome Statute. So, it has strengthened 4 Geneva Convention and 2 protocols. So, international criminal law or Rome Statute has taken note of the international humanitarian law, incorporated the principle. So, those who are responsible for violation of international humanitarian law, they are the subject before the international criminal court. They are subject of international criminal law. So, there is a close relationship, very close, deep, intense relationship between the international criminal law and international humanitarian law. In other words, what you can say that international humanitarian law is enforced through the international criminal law in situations where international humanitarian law has been violated by the state authorities or other military officials. So, it has strengthened the implementation of international humanitarian law. Today, I am discussing on the 10th March 2022 about this subject, and same time what we see in last 14 or 15 days, a new crisis, a crisis which has disturbed, which has disturbed all of us worldwide, that is the Ukraine and Russian crisis. So, this importance of this subject. So, like we are discussing as a law teacher, we are discussing, seminars are taking place, webinars are taking place, and people are expressing their view. Some goes through this subject, some goes without this subject, some speaks about the journalistic, some speaks about the more in the historical manner. But this is the occasion where we see what will happen next, whether Putin will be subject of international criminal law, whether like Russian government has committed war crimes, whether Russian government has committed genocide, whether Russian government has committed crimes against humanity, whether Ukraine has violated international humanitarian law, is there possibility of international trial, is there possibility of the International Criminal Court take this matter. So, these are the questions in days to come will become very common and very acceptable for the research and other purposes, and thus the importance of this subject remains very relevant in today's context and days to come also. So, this subject has a great relevance in the contemporary world. So, we talk about the human rights law. So, I conclude the first conclude to say that the importance of subject must be felt. The importance of the subject must be felt by the academicians, by the regulatory bodies, that international criminal law is going to stay. It has a relevance and it has to be given due recognition in the course structure of the LL.B or LL.M level. And I am sure that the initiative which has been taken will be covering this particular. So, I will just speak after this about the content and how to draft a syllabus of the international criminal law. Thank you.